This is the May 5th meeting of the Sacramento Metropolitan Cable Television Commission. It's being videotaped in its entirety and will be cablecast without interruption on Metro Cable 14, the government affairs channel on the Sacramento cable system. Today's item is being cablecast live and will be repeated Friday, May 6th at 1 p.m. A VHS copy is also available for checkout from any branch library of the city and the county. Members of the audience wishing to address the commission should fill out a speaker identification form located on the back table and give it to the secretary at the front here. Please speak into the microphone when addressing the commission and state your name for the record. Just one item prior to just an adjustment to the agenda, if it's agreeable to everyone. Sacramento Cable Television wanted to make a brief presentation just prior to us starting the rest of the agenda. I've agreed to that. If there are no objections, we'll carry forward with that item regarding specifically their general manager and what position they're in right now. So why don't we have a roll call?
Cox.
Aye.
Pratt.
Here.
Basanis. Collin. Here. Yee.
Here.
Toby Johnson.
Here.
Dickinson. Panay.
Here.
We have a quorum.
Okay, thank you. So with that adjustment to the agenda, may I call up Sacramento Cable Television to give a brief presentation on the status of their general manager's position.
Good afternoon, Mr. Chairman, Commissioners, and Commission staff. As I'm sure you've all heard, our General Manager, I'm Brian Gruber, by the way, Director of Marketing of Sacramento Cable. Our General Manager, Kim Ruckert, resigned recently as of last Friday. The system is currently being managed by the system directors, the five system directors, most of whom you already know. As always, we look forward to providing you with responses to any needs or communication or anything that we could be of service with. And in the course of today's presentation, you'll be hearing from 2 or 3 of the directors on various issues. So if there's anything during this transition period that we can be of assistance with, why, as always, please feel free to call upon us. I would like to make a brief introduction. We're pleased to have in town for this week and every other week during the transition period one of 2 vice presidents of the corporation who will take turns visiting with the system and assisting us in the management of the system. So if I can introduce for a brief hello, Wayne Vowell. Wayne is the vice president of Scripps Howard's cable division, and he would just like to greet you all.
Well, Mr. Vowell, come forward. It's a pleasure to have you here, and we appreciate you coming to town.
Well, thank you for having me. Allow me to take a few minutes of your time. I'll be out of your way. I know you have a hectic agenda, but thanks for the opportunity to present myself to you. What I wanted to do was just sort of give you a situation analysis where we were with the general management replacement, what the timetables are, and how we plan to go about managing the system on a day-to-day basis during this interim period. In terms of the recruiting process, we're putting on a national search. It's been underway for a couple of days. We have come across what we consider to be some decent candidates. We want to explore the possibility of searching in the local market as well, and we're in the process of trying to find, and if you do happen to know of some executive recruiting groups in the city that would be amenable to providing leads and whatnot for potential candidates, we would be more than happy to explore them. In addition, we have a few candidates internally that we would like to give the opportunity to put their name in the hat as well. I think what we will we're not under any time restraints. We, as you are probably aware and have experienced, we have a very competent director level of staff at the cable system, and I would like to take the opportunity to introduce one that you may not have had the opportunity to meet. His name is Alan Daniels. He is our newest director of operations, a very, very qualified candidate. He comes to us from Miami, Florida, and we are very, very happy to have him on board. He has been here for about 60 days now, and based on the feedback we're getting from the employees at the company, it was a very productive hire. So, Alan, welcome aboard, and I think you'll be hearing and seeing more of Alan in the near future. The other thing is that as a result of the level of competency that we have in our directors, we don't feel the need to rush out and hire somebody. We want the best possible talent we can get our hands on that will serve this community very well. And in the interim, what we plan to do is have Mr. Espasto's direct contact with the system will be Kevin Jones. He is the one that's intimately involved in all the new regulations, the FCC stuff, and for whatever staff would need relative to that, Kevin will be our point person. In addition to, we have access to all the other directors as well, but Brian and Kevin, for the most part, will be handling whatever your needs and concerns might be. We hope to have something done in the near future, but as I said, we are very comfortable with the management staff in place, and a co-worker of mine, Chuck Romano, some of you may have had contact with Chuck in the past. He has a long history with Sacramento Cable. He and I will be out here on a regular basis, not managing on a day-in, day-out basis, but just supporting the directors here in making sure that we are following through with our commitments and obligations to both you and the community we serve. So, having said all of that, thank you very much for your time.
Pretty good.
We are looking forward to a new beginning, if you will, and I think we're going to find this to be a very productive process. So, thank you so much.
Well, thank you, Mr. Vell. Appreciate you coming out today. Any questions from commissioners?
Oh,
Okay.
glad to have you here, and we
Well,
trust.
I was just in trying to figure out in terms of if people were to contact you with potential people to go through the process, who would they address those letters to?
They probably should be addressed to Steve Crawford, and I promised Rich this morning that I would supply you with both a name, phone number of Steve so that you could call him directly if you have a candidate or have some issues relative to this search process. I will do that, or we'll have Penny Costa
Is Steve Crawford located in
the
head
corporate office in Cincinnati, sir.
Oh, in
Yes, sir, he is.
Cincinnati,
He's the
okay.
senior vice president of the division, and he will be the one making the ultimate hire decision. Myself and Chuck will be part of the recruiting screening process.
Will
but
anyone submitting an application get an immediate acknowledgement of it so that they know that they're in the hopper?
Yes, sir. We will respond to anyone that has the qualifications for this particular position, and we will get back to them immediately.
Good.
We
Okay,
plan to have, we hope to come up with a long list, and we will eventually shortlist that and hopefully come up with a selection process from that.
Ms. Collins?
No, well, there had been just some concerns and issue of how you were going to go about that recruitment process and how people might get information or names or possible candidates to you, and I simply didn't know. So what they will do is get the name from the address. It's a Mr. Steve Crawford
Right,
in
and
Cincinnati.
if
You'll
by
have it.
chance there are people here while I'm out here or Chuck is out, we'll be more than happy to talk to them while we're here as well without having to go to Cincinnati to visit with Steve. But clearly, you have Steve Crawford as the contact. He's the key person relative to the hiring process, and Rich will have all the appropriate information relative to reaching Steve.
Okay, thank you.
Okay, but I must share, we're very anxious and hoping that there is a local candidate. If that's a way we can accomplish this, and you have some valid names and people, we would love to have them.
Well, it's nice to know how the process is going to work, because
Sure.
I think there has been some concern in the community about how they're going to have any input
Sure.
into your choices. Okay.
We want you to be pleased with who we hire, so we would like for you to be involved as well. So.
Well, thank you very much, Mr. Vell, again. And Mr. Daniels, welcome to Sacramento. You finally arrived. As we all know, Miami's a nice place, but if you'd like to come, huh?
No humidity.
Sacramento, we all consider God's country, so I guess you're here.
I just wanted to just take a moment and tell you I'm looking forward to working with you, and actually I'm excited about being here. Actually, I was hired back in January, but I had obligations in Miami with my past employer, TCI, and I couldn't make it sooner. But I just want to tell you I'm looking forward to working with you.
Well, good. Well, welcome.
Thank you.
Welcome very much.
Nice to have you here.
Okay. All right. Item number 1.
Mr. Chairman, members, good afternoon. Last month, we brought to you some recommendations and broad guidelines to do two things. Essentially one thing, to respond to the grand jury report of a month ago, You gave us some guidance and asked that we prepare for you a grand jury response and ex parte regulations model after a PUC broad general model. You also said that there were two areas, triggering event and timing, which you left to staff's recommendation. With a considerable effort and several drafts back and forth between Council Steiner and myself, we're recommending to you today a response to the grand jury, and also that you adopt ex parte regulations. The regulations before you pretty much follow what the general pattern the general guidance you gave us last week. But let me summarize them very quickly, if we may. One, that ex parte communications would be prohibited following the effective date of as issued by a special notice included in your packet, and would continue until 30 days after the triggering event. The matters subject to an ex parte notice are specified in the regulations and include such things as franchise termination, rate determination, regulation enforcement. There's a provision for a general provision which would allow the executive director to notice you of an ex parte communication that isn't already detailed or prescribed in your regulations, but would give you the opportunity to rescind that order at your next regular meeting. The concern there in staffing this and analyzing this was that a situation might arise that we haven't anticipated relative to the regulations. So the recommendation there was that the executive director could notice, and then at your next meeting you could rescind that if you felt that was the appropriate action. Lastly, in reviewing some of our past behaviors and past practices, I thought we needed a vehicle in the regulations wherein the commission could in advance authorize an ex parte communication amongst yourselves. The example might be that there is a decision being negotiated or discussed in which it is desirable to have the guidance and participation of one or all of you, and that by a affirmative action of finding that such an action on your part was in the public interest and public policy, we could move forward. The example I give that in some of the negotiations in the past on issues going back to the lawsuits 5 or 8 years ago, you chose to designate one of yourselves as the lead negotiator. In this case, you could do that and would affirmatively act in advance, and thereby the ex parte prohibitions would not apply. In addition, with Harriet's much work is a draft for the chair's signature, which would be what we envision now and recommend now is the total response to the grand jury. Harriet, do you have things you'd like to add?
I think you covered just about everything I was going to say.
Okay.
Unless you have questions.
That's good. Harriet, we don't pay you by the word, so you're all right. We appreciate that too, though I will tell you. Yes, Mr. Yee.
Rich, I'm a little confused on the word ex parte. Could you explain that to me in my language, simple terms, as just what that means?
Yeah, it means a communication that's one-sided, so that if you were if you were doing an enforcement proceeding and a franchisee was on one side, and in your particular case, basically your ratepayers are on the other side, and it prohibits those parties to the action, which in most cases from a practical standpoint will be your franchisees and licensees, from communicating directly with the decision makers, which is the commission, during the term of the enforcement action. So it helps to distance the commission from outside communications that you would get that wouldn't be part of the formal record that comes before you for a decision by the commission.
Now that would work both ways. In other words, but it has this item has to be noticed first, or this.
The way we structure the proposed regulation is there's a list of those types of proceedings that this would apply to, and they're your more standard, more judicial type proceedings. Okay. The executive director, Rich, would send a notice to the commission members and to the parties to the action, telling them that this rule applies to this type of proceeding, and as of whatever date, let's say, an appropriate date, that there should be no communication between the parties and the commissioners. Okay. That lets you decide based on the record and the information that comes to you in a public forum on your decision. And then that bar would last 30 days after your decision, which basically covers the time for, formal written decisions and whatever kind of follow-up there is from your decision. And so it more or less insulates the commission from hearing about matters except in the public forum. Yeah. And then we put in an exception, as Rich discussed, that would allow the commission as a body to decide that it's in the public interest to have specified types of communications. And the best example, I think, is if there was some interest on the part of the parties to try to settle a matter, and the commission felt that it was in the public interest to have a subcommittee of your board or one member of your board be a participant in those settlement discussions, that the commission could take action by majority vote to authorize one of your members to take that role.
But these notices will be sent out before this action is...
Mr. In your packet, right after the formal regulations, is a sample of the notice. And it's something we should probably all be familiar with.
Yeah.
That would be an alert to you that at some point forthcoming, that discussions on a topic as specified in this section would be banned.
We wanted to try to draft a rule that was hopefully clear and easy, and we wanted to make sure that the commissioners and the parties had sufficient notice of the rule and the application of the rule so that there wouldn't be any, misunderstandings or surprises or, things like that. So people could be clear as to when the rule started to apply, what the rule said, and how long the rule was going to last.
Okay. And this will also apply from the public. Once we receive this notice, we can't accept any comments from the public either.
On the specific item, that's right.
Yeah.
The specific items are listed, and they're fairly narrow.
Yeah.
Enforcement action, rate determination, franchise determination. It doesn't prohibit you from talking to constituents or one of our cable operators on a routine consumer constituent problem or anything else that's related.
Well, that's where I get a little bit concerned, because when you get to that last sentence, and customer service regulation enforcement, that's pretty broad.
No, that would only be when we were in an enforcement mode. That would be at a point when there had been, or in the process of making a probable cause determination that there'd been a violation.
All right.
It doesn't deal with the day-to-day, my cable bill is unclear, I don't understand it.
All right. Okay.
Supervisor Cox.
Spry, could you, go ahead, Mr.
No, I'm through.
Could you give me, perhaps staff could give me a instance where 100% of elected board supervisors or commission legislature where there is ex parte rules in effect? Just give me an illustration. I understand the PUC is appointed, not elected. Give me an illustration of an ex parte communication of elected officials on a 100% elected official board.
I cannot give you that type of an example.
Are there any out there?
I don't know.
Would it be your judgment?
Most of the bodies that have ex parte rules are appointed quasi-adjudicatory type bodies like the OSHA boards, the workers' comp boards, the PUC, those types of agencies. When you come to the local level, where elected boards are acting both in a legislative fashion at times and in a adjudicatory fashion at times, there hasn't been, that I'm aware of, too many boards that have sat and said we want a strict ban. Now, the Coastal Commission has an ex parte rule, and
is the Coastal Committee elected?
Some.
But I've asked the question about 100%.
Yeah, I can't give you an example.
When you indicated that there were not too many, are there any?
I don't know that there aren't some that have their own rules that I'm not aware of. I am not aware of any elected board on a local level that has adopted this type of rule.
What would be your general observation as the difference between being elected and appointed as it relates to the ex parte communication? Why do you think that has occurred?
Well, I think that, well, on the state level, I think the elected officials deal almost exclusively with legislative matters, and so this has not been an issue because this doesn't come up in a legislative context. On a local level, I think that over the years there's been a blurring, and by and large, the types of activities that boards of supervisors and city councils and the like deal with that are adjudicatory are more along the lines of zoning matters and those types of things. And there's been a blurring, though there have been some cases over the course of time where the courts have talked about adjudicatory matters and having a non-biased decision maker. But there hasn't been that much of a push on the very local level to make those strict determinations. Now, I can't say that there isn't an elected city council or board of supervisors when they're acting in a truly adjudicatory type matter, let's say, you know, a nuisance abatement type matter or some of those types of matters where they don't have a strict ex parte rule that applies to their proceedings.
With respect to the cable commissions, which I presume, and this may or may not be accurate, do we know in California the cable commissions, are there any that have ex parte communication?
I put some reasonable efforts in trying to determine that. First off, there are very few cable commissions in existence. I did initiate a nationwide survey with contacts and sources that I have, and I have not been able to find any.
Do you know of any public utility that has ex parte communication where you have 100% elected officials? For example, SMUD?
I'm not aware that SMUD has ex parte rule, but I have not looked directly at it.
So the system works reasonably well throughout the country. What would be your judgment as to why you think this board ought to sign that today?
I think that these types of rules, when you're dealing strictly with adjudicatory matters, which is what we have tried to limit this rule to, insulates the board from allegations that the board is acting interested on behalf of one party or another party to the decision. And it helps support your decision as being a decision that's made in a non-biased manner based on the record in front of you.
I would add that one that within the cable television environment, and since the Cable Act has been implemented or was passed in 1992, the provision of rate determinations brings a new facet to the type of decisions that we've previously dealt with. I think as we look back over the last 10 years, most decisions have been legislative, and very, very few have been regulatory. So there's a change in the mix of issues before you. In addition, this report back to you today in recommendation is done in response to your guidance of last month, where we discussed it at length, adjudicatory versus legislative decisions and the issues we were trying to respond to the direction provided to us.
Mr. Chairman, let me just remind this board that there were no allegations of wrongdoing as I read the grand jury report, only a suggestion that it perhaps might be in this board's best interest to do that. And I still question the wisdom of that. There may be members on this board who do not believe that they can look at subjective material and make an objective decision, and I think that I understand that. But I also want to point out to this board that there is clearly a distinction between elected bodies and appointed bodies, and historically ex parte communication has been limited, if you will, to boards that are appointed and not those that are elected, and I ask you to take very serious consideration when you vote on this particular matter.
Just in follow-up to that, Mr. Cox, what do you see the difference between an elected body and an appointed body, and how it one maybe should have ex parte and one shouldn't? You're obviously implying that elected bodies shouldn't have ex parte.
No, what my implication is that my constituents believe that, at least those that the majority believe that I have the ability to look at a subjective matter and to make an objective decision with a value judgment. Day in and day out, we are all in a regulatory mode, whether it has to do with land use or traffic situations or rates. I served 4 years on the SMUD board, and the SMUD board has a direct impact on the rates and does not have an ex parte factor in their deliberation as far as rates are concerned. And it just seems to me that we ought not to rush into this just because the grand jury suggested this. The grand jury did not interview the majority or any member of this board, and it just seems to me that we're rushing to do something because someone on the grand jury got something from someone that said we ought to do something, and there is no allegation of wrongdoing. Just want to make that very clear.
Okay. You're absolutely right.
Thank you, Mr. Chairman. I've got a few questions on the proposed ordinance, but I can think, Dave, of a set of elected officials who are virtually 100% elected officials who are subject to ex parte communications prohibitions, and that's judges.
Who?
Judges. Judges are elected in this state.
That's right.
I've got some questions, starting with 1A, and the prohibition applies to members of the commission, and then there's an indication the prohibition doesn't apply to staff, officers, consultants, and legal counsel of the commission. I don't have a problem with that distinction, but what occurred to me was the practical issue of someone who writes to us or makes a phone call to our office. Certainly, if we adopt this, we have to implement a system in our office to sidetrack those communications, but from us. But the question that raised in my mind is a practical one: is how, or whether the intent here is to keep our clerical staff or our administrative assistants from reviewing or seeing or having conversations, seeing mail, that kind of thing that would otherwise be subject to the prohibition on ex parte communications. Have you thought about that?
We hadn't really. I mean, the idea, I think, of this, which is what I took from the commission's conversation last time, was that the commission members themselves did not want to have a communication with the parties to these particular adjudicatory matters, and so I would assume that would go to your staff as well. This didn't really. This just addressed the commission.
Okay. I mean, I'm not sure what the answer to this is, but it's impossible, obviously, to avoid opening a letter and taking a look to see, at least in general, what it addresses, or just saying, I can't accept a phone, tell me what you're talking about. If you say cable in this vein, goodbye.
Well, we would hope that, that by sending the notices out not only to the commissioners, but also to the appropriate franchisees or licensees, that at least from that side, they would be forewarned not to make that telephone call or that contact.
Yeah, I don't know that we should add language to clarify what the nature of, that we can acknowledge receipt of the communication by the staff or something of that kind, but limit it to that. That's just something that struck me as I read this that is unaddressed.
Right. Well, there is a provision at towards the end of the regulation that talks about what happens if a communication actually occurs, and allows somebody to say, okay, I got this letter, here it is, and basically give it to the rest, to the commission staff, and have the commission deal with that if appropriate.
Right. Okay. The next question I had to do with B sub 5, which includes rate setting proceedings, as I read it, within the ambit of adjudicatory proceedings. And if you are talking about rate setting, tends to strike me as a legislative function more than an adjudicatory function, especially if you think about the fact that you could have more than one franchisee or licensee.
The rate setting referred to here is rate setting for a particular franchisee or particular under the Cable Act.
Rather than general rate setting.
Right.
Okay. The other The other thing that raised a question in my mind is on page 3, and it's 3B, which is the remedy section, which I thought was somewhat vague in the sense that it doesn't specify against whom the various sanctions may be imposed. Are members of this commission, for example, subject to the imposition of monetary sanctions by the majority of this commission? What is the authority of this commission to impose monetary sanctions on members of the public, regulated or others? Perhaps there ought to be some specification of limits in terms of monetary sanctions. If that's something that we're going to accept, I'd hate to see I'd hate to have $1 million fine against me for talking to the wrong person. I don't know, the rest of you might be comfortable with that.
Well, $1 million's not bad, but we're getting 2 or 3 million now.
Oh, then it's something to worry about, huh? Well, easy for you to say, you're retiring.
Well, the county would pay that, obviously.
Yeah, obviously.
In our positions on the commission.
Individual commission members get that pleasure.
It's clear the commission can limit this in any way that you desire to do so. When we drafted this for your consideration at this point, we tried to just give you as broad an authority as you can to use it in the appropriate situation, because in talking about this and trying to structure a rule and discussing it with Rich, and looking at other things that had happened in other types of situations, violations of this rule can go from the purely innocuous to the totally grievous. And it's it's hard to structure a particular one particular remedy that would you wouldn't really want one particular remedy for every one of these situations.
I agree. I mean, I think a range of remedies is entirely necessary and appropriate. I think we need to. My own view would be that we need to add some definition to this. It appeared to me that you were, to a certain extent, grafting the discovery sanctions out of civil litigation, which frankly I think makes some sense as you've modified them, but I still think there needs to be some more definition of the limits of both the range and the degree of penalties that might be involved. Having said all that, I think that this is an excellent effort in dealing with a very difficult area. And so I commend you with respect to doing that task.
Well, thank you.
Thank you,
Okay.
Chairman.
Yes. Any other questions? No? All right. No other questions. Well, we'll go into public testimony then. Mr. Wayne Vowell, did you want to speak on this item? Okay. Ms. Darby Patterson, did you want to speak, Darby?
Mr. Chairman, you may want to just formally open the public hearing.
Okay, the public hearing is formally open. Ms. Patterson.
I'm Darby Patterson, Community Relations Manager at Sacramento Cable. In going forward with your ex parte rules, we want to say that if you in fact adopt these rules, that we're very happy to comply with your regulations. And we want to assure you that in keeping with your own clarification that your commission has acted completely ethically in relationship with our company, we also want to make it very clear that representatives of Sacramento Cable respect our regulatory relationship, and we have not sought private conversations on matters being adjudicated, and we do not intend to do so in the future. We want to have better communication as we create our company's strategic plan. We're working on that right now, and any kind of input we can get from you in the future will be very much valued, because you're in direct line with your constituents, who of course are also our customers. And it's important that we design our future in regard to technological advances and customer service, new business opportunities, and a host of other things, really in line with what you know and what your constituents and our customers are telling us. So it's really our desire that we manage a system that not only meets the needs of the franchise area, but really goes beyond your expectations of us. And that's really what we're striving to do. And we hope that you're going to accomplish that by keeping some lines of communication open for us when it's appropriate. And we're very, very happy and pleased to comply with any regulations that you might feel the need to adopt. Thank you so much.
Okay. Thank you very much. Well, there's no other testimony before the body. Any other member of the public like to speak on this item? Okay, seeing no one
Let me just ask
coming
one
forward.
additional question.
Yes, Mr. Cox.
Let's assume for just a hypothetical situation for just a moment. I think there seems to be a greater concern about communicating with the cable company than there does with constituents. Does it prohibit communication with constituents as well?
Yes.
During that period of time?
Yeah, any person.
On the particular specific issue, with respect to anyone who's on either side. So if it was a enforcement action that dealt with customer rates or something like that, it would affect those customers as well.
So if, for example, there was a rate promulgated that said the rate will be $10 as opposed to $9 for a particular item, and during that period of time we wouldn't be able to have that discussion with the constituents as to whether the rate ought to go from $9 to $10, for example?
Unless the constituent was here.
And this might be someone who couldn't get downtown to talk to us.
Can they enter their letters into public hearings?
They could send letters to the commission staff, which would be then forwarded as part of the public communication packet.
And what if we were to receive written communication from someone regarding a rate matter? What would we do?
Assuming that this rule applied, you would forward that to your executive director with a notice to when you got it, and you would send it off, and that would then go to the commission. I would guess at that point that it would be a very minor violation of the law of this regulation, considering that it was just a letter that you got, and the letter then went to all of the interested parties.
Let me just be sure I understand one more time. Just say it again so that I can understand. We as the elected representatives and as a member of this commission, someone has a complaint during a period of time where we have negotiations going on about rates or services or something, and if we receive a letter, it then becomes a minor infraction as far as this.
If the letter had to do with one of the specified proceedings listed in the rule, or a specified proceeding that you either add to the rule, or is determined by your executive director and not overruled by the commission to be the type of proceeding for which you want this rule to apply. So it would apply.
What would happen if the staff person opened it and sent it on? How would we?
One of your staff members opened it and sent
or
it?
Mr. Dickinson's?
Right. That would be fine. Would just forward that to to the commission staff, and then you would receive that as part of the
agenda packet.
As part of the agenda packet, which would then be the equivalent of receiving it in a public meeting.
Have it distributed to whole board.
It would become a communication available to all of you, and then theoretically all parties to the suit. That would be the public who have access to our agenda packet, as well as the cable company, which may be the subject of the rate determination.
Well,
yes, Mr. Yee.
Well, following up on that comment, if the cable company sent me a correspondence with a copy to everyone, or a constituent did the same thing, that would not be a violation. Is that correct? Because the full board or the commission has access to that information?
The difficulty there is the theoretical one of who are the interested parties to the issue, and have all the interested parties, that is theoretically all the consumers, had access to that communication. And a correspondence to you under this process doesn't do that. But
in
under
all practicality and all the time that we've functioned, how many of these would you ever expect?
Ms. Collins, I'd like to just hear Mr. Esposito out, if we could just finish his comments. And then
I thought he did, and I thought he was going to. I just wanted him to say how many times would you expect we would ever be into adjudicatory proceedings?
How many times do you
Very rare.
We've had, under the regulations before you, we've had and have currently two. One is there's a rate determination pending pursuant to the certification of the FCC's rate regulations, and there's an enforcement proceeding pending pursuant to your November 4th probable cause determination. Those are the only two that I would be aware of.
Okay. Mayor?
A minor violation, if you open a letter, an illegal letter, a minor violation against who? I wasn't too interested in this until you got to that point. If I open a letter, I've committed a violation without knowing the contents of the letter?
No.
Yeah, I can't.
No, you said, no, isn't that what was said?
I think so.
If you open
Yeah,
a letter and it's a violation type letter, it's a minor violation.
The idea of this rule is to prohibit other people from communicating with the commissioners. Now, clearly, that encompasses within it commissioners seeking them out to talk about this particular issue, because they're not supposed to talk about this particular issue with the commissioners, because, you know, to the extent that there is an issue that falls within this, one of your enforcement type proceedings. If you got a letter and that letter was then forwarded to the commission staff, yes, you could probably say that was a technical violation of this rule. But I don't know any way to draft, I mean, to the same extent that if I sent a letter to a judge and didn't tell the lawyers on the other side that I was sending the letter to the judge, that would be a violation of this rule. Now, if somebody, you know, I've been involved in litigation that's, you know, of interest to many people in the community, and citizens will write to the judge, and the judge will generally take the letter, mail it out to all counsel, and that's the end of it, because there was nothing there particularly. But I don't see how, you know, in this type of situation where you have, you know, where one side is basically all of the consumers of the cable system, and the other side is the cable franchisee, I don't see how you can draft a rule that says it's okay to write you a letter, but it's not okay to have oral you know, to have an oral conversation. I think it's hard to draw those kinds of lines.
Well,
and so, to me, it seems the better line is just to say it's prohibited, and if it occurs, ship it off to the commission staff. They route it to all the appropriate people.
It becomes part of the record.
And that's basically, you know, and that should be the end of it.
Well, members, I'm somewhat taken by what Mr. Cox has said regarding the grand jury's report, that there was never any wrongdoing found by the grand jury. I'm somewhat taken also by the comments I hear about the ability for constituents to correspond with us as constituents of ours that we're elected by. And so I'm not quite sure whether we're ready to proceed with this item and whether we should postpone action on this item and keep thinking about this.
May I make a comment, Mr.
Yes, Mr. Dickinson.
I think this conversation, I don't think it rises to a controversy. Conversation about letters is really much ado about nothing, as long as the procedure is clear. I mean, you're not prohibited from receiving communications from your constituents, even on those issues which are subject to something that falls under this proposal, because all that would happen is, presumably, you forward it to the commission then makes it part of the record, and we all see it, including all the members of the public who might care to, and it becomes a part of the official record.
Well, I get phone calls at home from my constituents, and I guess at this point then I would have to tell them that I can't talk to them about a proceeding. They want to give me their view to say that the rate should be whatever, or they want to tell me that the cable operator has no right to do boxes or a specific item. I understand the boxes or a specific item. Am I going to tell my constituent?
No, I think again it does not.
Well, let me just understand. Am I going to tell my constituent that no, I can't speak to you about this particular item because there's an ex parte communication rule the commission has?
Sure. I don't see I mean, lawyers do it all the time. A client on the other side will walk up to you and say, you know, I'd like to talk to you about this, that, and you politely explain that you are not permitted to do that you can't have a conversation with the substance, that conversation, if they're represented by lawyers, has to come through the lawyer, for example. It's not an uncommon event, and it's not that difficult. I think that it is entirely permissible and reasonable to say that is something that the Cable Commission has determined is communication which ought to be made in the public setting and forum, and you can write a letter to the commission, or you can come when this is heard. We'll make sure that you know when the hearing is on this, and then you will have your opportunity to address not only me on this subject, but the public and all parties as well.
Well, I've always considered myself an extension of my voters. That's why I consider myself here. But I think all in all, my sense of this issue at this point, because I do want to look closer at the grand jury report, because I do have a sense of what Mr. Cox is saying to be true, that there was no allegations of any wrongdoing, there was no proof of any wrongdoing, and I want to get a better sense of that report to comfort myself personally. I'm not sure where the rest of the commissioners are, but I'd like to study this further. Mr. Cox.
I just simply wanted to say to my colleague, Mr. Dickinson, I think there's entirely the matter between attorneys and client, that's an entirely different situation. Not only do we take in the 4th Supervisorial District, do we take calls from the 4th Supervisorial District, but we take calls from the entire district, from constituents who are not aligned with a particular supervisor in a particular area, and I rather suspect that those supervisors get calls from constituents of the 4th Supervisorial District that are not entirely aligned with the supervisor of the 4th Supervisorial District. It just seems to me that this whole matter, the letter issue of having to send a letter off, the potential of creating a violation, as this document calls for, the fact that the potential for just being set up by a vindictive person who for whatever reason, all of a sudden decides that they're going to make a big issue, they're going to come here and say, well, by the way, I called you last week. And we talked about this, and it may very well have been at the end of the conversation, they said, and oh, by the way, I want to talk to you about rates. And you say, I can't discuss this with you. There's a denial. They come here and deny that conversation ever having taken place. This thing is fraught with loopholes. We ought not to adopt it. We, in fact, ought to have the grand jury, if they're interested in seeing that ex parte communication comes forward, we ought to have a meeting with every single member of this board and talk about the issues with the grand jury so that they have a clear understanding. I call to your attention the grand jury report. They indicate that they have only talked, they have not talked to any members. They have, in fact, listened to videotapes. They make some statements about certain issues that even experts don't make. After years of experience, they tell us how good things are, how bad things are, and yet they have not visited with a single member of this board. And I continue to resist jumping because of the fact that there was a call for an investigation. At the time the call was made, this board had the opportunity. We discussed. Do we, in fact, want to have some sort of ex parte communications? This board said we don't need that. We're all elected by our constituents. And yet the grand jury has taken it on itself to make that determination without visiting with a single person on this board. Now, do they have to visit with somebody on this board? The answer is no. If one person out of 12 can get 12 people to agree that, yes, we ought to put something in here, and I'm not suggesting to you the grand jury is not a serious body and ought to be taken seriously, but there is no call here for wrongdoing.
Okay. Thank you, Mr. Cox. Any other member? No other questions?
I don't have questions, but I'd like to respond.
Okay, Ms.
Okay, because I feel that we're going back over a lot of material that has been discussed and hashed over and over again. It's been obvious from the very beginning that Mr. Cox does not agree with any of the recommendations made by the grand jury.
No, ma'am, that's not what I said. Please don't misquote me.
All right. Well, through the chair,
right.
let's have some statements
okay.
by Ms. Collin, and then we'll.
That Mr. Cox just does not agree with taking any of these steps. I'll put it in those terms. Your statements stand for themselves, Dave, as they have for meeting after meeting after meeting. I think when you are in proceedings that are of the adjudicatory nature, whether you're an elected official or an appointed official, there should be a perception on the part of the public that what you are hearing is being heard by everyone in open public hearings, that you are not being approached by one side or the other in behind-the-scenes conversations where a lot of different information can be imparted that then never finds its way into the public hearing. I think the perception is reality in that case, regardless of how well or objective you think you might be. Or I think I might be. The perception out there is that we are being lobbied behind the scenes, that we are hearing things that perhaps no one is getting into the public record, and that therefore, what are the rules of procedure going to be? I think that, I congratulate you for drafting a good response to the grand jury, as well as coming up with the type of regulations that I think we really need to have as a public body. I think it lays that to rest, and I think all of the things that you've been stretching for to find and use as examples are examples that are easily taken care of, because this is a procedure that is not going to be used very often by this body, but when it is used by this body, if we receive letters or phone calls, there is certainly a remedy right in there of what to do. You report those calls, or you send the letter on, and certainly that's full disclosure. And I think that that's what all of our constituents also want, is a full, open, public hearing and full disclosure.
Okay, Mr. Cox, you had some.
Oh, this gets into a contest it becomes a situation where Isla requested this, that we have ex parte communication. The board, in fact, decided that it didn't need it. What she's really saying is that everybody else on the board doesn't have the ability to receive the subjective material and make an objective decision. She thinks that she has the ability to do that, but she doesn't think anybody else has that. I'm resistant to that, and I'm very respectful.
Dave, that is absolutely untrue,
okay,
so we'll always disagree with each other. But you don't characterize me, I won't try to characterize you.
Okay, if we could just work through the chair here. Any other statements, Mr. Cox? No other statements. Mr. Yee, anything?
No.
All right.
And clarification, I ask only for a report back and a public discussion of that by this board. I did not at that time even indicate that I was in favor of doing it. I wanted to find out, since the PUC had them, other groups had them. I even wanted to report back on that.
Okay.
That's what you
Two
didn't
questions
hear.
from the chair. Mr. Espasto, under these guidelines, if someone were to call about the item in question that may be covered under ex parte and ask what the procedure was, what the timeline was, how the body decides on those types of things, the kind of the procedural questions, is that considered ex parte?
I defer to counsel, but under the concept that we try to respond to, I would think not. Those are procedural things. But in the example Mr. Cox used, where someone calls with an opinion and it's trying to provide you data with which to influence your analysis of the issue, that would be. So my offhand comment would be, no, that's a procedural matter, not speaking to the point of the content of the issue.
Are the ex parte, like with the PUC, is that considered the same? Is that how they consider that, or is it if you're asking procedural questions, how the commission operates on this particular item?
I believe the PUC rule actually has an express exclusion for procedural questions.
Oh, they have an expressed exclusion. Okay, members, I don't know. My recommendation would be that we table this item and that we look closer at it. As I said before, I'm concerned the impression possibly that we're reacting to the grand jury report with this type of response. I'm concerned that perhaps there's an implication from doing that there was some wrongdoing happening before. I'm also concerned that constituents continue to be able to talk to me freely. I've made a policy, as I've been in office for the last 5 years, I stand out on the sidewalk and talk to constituents. And I schedule those times so people can talk to me. So I have a problem if that isn't the way it's going to be. For those of you who don't know me, that I do stand out on the sidewalk and talk to constituents. So, but I understand
Josh,
that.
could I respond to that? Because
Yeah.
The one difference I see is, I don't think that you do that when the city is involved in litigation and you're under an exec session rule in terms of discussing litigation.
But I still listen. I've had, on several occasions, people who felt they wanted to get their 2 cents in on a piece of litigation that was before the council in executive session. Now, I was not privileged to divulge any of our discussions in the closed session, obviously, but I was very privileged to sit and listen to their viewpoint on who should be suing who and why. And that's happened on many occasions. People have called me at home, late at night, early in the morning, wanting to give their viewpoint on litigation because they saw it in the paper. And they said, I'm going to call my council member and have my view. No. So it concerns me on that point. I don't know how we respond. What's the, we have 90 days, so when is that 90 days up to respond?
The order from the judge requires a response by June 4th.
June 4th. I wonder if we could... If we could direct our executive director to redraft the response, looking at the response that we have drafted in front of us, and redraft it. You know, if the commission doesn't want to take action on the ex parte at this point in time, we could obviously tell the grand jury that we've considered it. We've analyzed it, we've looked at it, and at this time do not look forward to moving ahead with it. If that's the will of the commission. Mr. Johnson just left, said that he agreed with Mr. Cox. I'm sure he can come back and speak his mind as well. But I'm not sure where the commission is, but that would be my recommendation. Mr. Dickinson.
Let me make a couple comments here. First of all, I don't object to spending somewhat more time in the development of this, and specifically to give the staff a reasonable opportunity to respond in greater detail to any of the issues or questions that have been raised here. I think they are largely make-weight in kind, but nonetheless, members of the commission deserve response to those, I think, and the staff deserves a fair amount of time to provide a measured response to that. I think there are some refinements to this, as I suggested earlier, that might be appropriate, and I could, if the normal course of events doesn't permit us to adopt this in time to respond to the judge, to amend the response to the judge to the extent of saying we are continuing to work on the adoption of this kind of measure. But I think we ought not to table this, as I understand the meaning of that term. I think we ought to we ought to continue to work to come up with a proposal that we believe is suitable, appropriate, and practically feasible. There's been a substantial question raised, in my judgment, about the fairness and appropriate proceedings before this commission. It is, by and large, a unique setting for us as elected officials, both in terms of the city, the county, and the combined boards and commissions that we sit on. It is one in which there is particular and significant interest and unique and different players, almost unlike any other circumstance that we face. We owe it to the public that in such a setting there's absolutely no question about the fairness of the proceedings that occur here, especially the kind that are the subject of this proposal. And so therefore I think it is appropriate to ensure that confidence in what we do, that we have this kind of limited measure that will give that kind of confidence. So I'm opposed to tabling it, if by that you mean delay or not pursue this on an indefinite basis, but I am not opposed to allowing a further chance to refine it.
Mr. Chairman, let me just say I concur that we probably ought not to table the grand jury response. We ought to adopt recommendation 2 as it's been proposed and recommendation 3 as proposed. And then relative to recommendation 1, I think it's fair for us to say to the grand jury that we have a difference of opinion on this board, and notwithstanding the fact that they have not alleged any wrongdoing, that while there is maybe some will on this board to draft some sort of regulations, we do not, in fact, agree. There doesn't seem to be an agreement as it relates to the regulation that has been drawn, and that this board will continue to work on the matter. It may or may not come out as an ex parte communication exclusion. I was just thinking also, as we were looking at the community service districts and all of those various items, and almost daily, certainly monthly, in the Board of Supervisors, and I suspect in the City of Sacramento, you are in a regulatory setting. And I think we can, just as a side, I think we can go ahead with the response to the grand jury, and we can tell them that we don't have agreement as to whether or not there's need for ex parte, and then adopt 2 and 3.
Okay.
Mr. Chairman, Mr. Cox, just like to point out that as prepared by staff, the response to grand jury recommendation 2 is in substantial part founded on the ex parte regulations.
Yeah, I see that here. So that doesn't seem to be proper. I think what we should do, members, is direct our staff to go back.
But we have the ability to delete the regulation
on the
parte as it relates to the Brown Act.
Yeah.
We can just delete that section.
We could just delete that section Mr. Cox is suggesting on the ex parte with reference to Section 2. You're saying that part of our response was that we were adopting this ex parte regulation.
That's correct.
Mr. Chairman, whether or not on this commission, as well as every other commission and board on which we sit, we are governed by the Brown Act as amended and just promulgated. We've all had indoctrination and orientation as it relates to the Brown Act.
Okay. Well, the will of the commission at this point, I guess.
Well, I've heard 2 people speak very strongly and 2 others speak very strongly. I haven't heard 2 others.
Well,
and I'm not sure now that Mr. Johnson has left where that particularly leaves us, but I have to concur very strongly with the recommendations and the sentiments expressed by Supervisor Dickinson that this is a unique situation to have a cable commission. There's obviously large monetary interest here regarding any of the proceedings that we take as it affects the franchisee and as it affects the consumers. And I certainly would have been prepared to go forward with this today, and I believe very strongly we should. That we owe that kind of a duty to our constituents and to this community. And I certainly think much of what has been brought up here today is still, I would use the word smokescreen issues, because it is not going to prohibit us from talking with our constituents, hearing from our constituents. All it is saying is that we have a duty to go ahead and report those and get them into the public record if it does occur, and when we're in these type of proceedings. As it relates to everything else we do as supervisors, as city council people, or as cable commission members, we are completely free to have those discussions. So that's not the real crux of the issue. I think in terms of proceeding today, that we are under a duty to respond to the grand jury. I don't think we have any choice of that. I know when we receive a report as county supervisors, we respond to each and every recommendation made by the grand jury. And we sometimes concur, we sometimes don't concur, we sometimes indicate what action we will be taking. And I would think that if no one feels ready to adopt these today, or they do not feel that they're going to want to adopt them in the future, or they want to take a further look at them, refine them, we ought to at least indicate in a very specific way what we're going to be doing.
Okay.
In that response, particularly if we're not meeting before June 4th.
Council, is it possible the chair can make a recommendation, a motion? I can't remember on this body if the chair can make motions or not.
Mr. Chairman, Ms. Collin raised an interesting question, and let's hear what the mayor has to say, and let's what Mr. Yee has to say.
Well, I was going to make a recommendation, and they could see if my motion. Huh?
Well, before you do that, let's hear from the two of us.
If
Go ahead, Jimmy.
Mr. Yee.
I have no problem doing that.
Mr. Yee.
I guess you might consider myself sort of a middle road. I came in here with an open mind trying to figure out just what this regulation is going to require of us. I've heard two sides and very strong opinions on both sides. Currently, my feeling is that I'm not ready to support this the way it is written. I'm not opposed to continuing to look at this because all I can do is judge what the situation is from what my perception of it is. And I certainly don't find myself doing anything wrong as far as communication is concerned. If this is passed, I just felt that it might be too restrictive. That's why I wanted some clarification to just exactly what ex parte means. I'm not a real intellect to understand all the legal terms. I do feel that it does hamstring us to a certain extent. I agree with what Mr. Panay has said on many of his comments. At the same time, I agree with Mr. Dickinson as to, hey, maybe we should not table this, but perhaps take a look at it and see how we can clarify it, if there is such a thing as clarifying what we really want without hamstringing our operation.
Okay. Mayor.
I was going to vote for this, even though I was offended by it when I got the packet at home, and started reading it. I was going to vote for this just to put it behind us. I don't think we want to fight the grand jury. So that's all I had to say. That's why I said I truly did not have that much interest in this one or the other, but I was going to vote for it just to put it behind us and go on with our business.
Okay. Well, I might recommend, have you figured that one out yet?
Oh, you're allowed to make a motion.
I'll move that we write the grand jury and in the draft letter. Yes, ma'am.
You hadn't closed the hearing, and I believe, and there was number public comment.
We have Mr. Maynard Nelson, who is with the grand jury.
Okay. Sorry. We have one last speaker, Mr. Maynard Nelson.
All right. That was a spy here.
Is it agreeable that I speak to you as a private person?
Well, I didn't introduce you as a member of the grand jury, but go ahead. You can.
First of all, I've heard comments that it seems that it should be made clear in each of your minds that there's a difference between your regulatory status and your legislative status. Secondly, while there were I've heard nothing about any allegations of wrongdoing, I would think that this would be something that you would welcome as a protection because of any, gives you an opportunity to tell somebody who wants to talk to you about a regulatory issue that you can't talk about it. Because the perception is, without this regulation, there would be a perception if you're left free to have that kind of a discussion, it can be very improper. And I think you would find that enforcement or any enforcement of trying to determine a prosecution to determine that there was something improper is impossible. A private conversation between yourself as a regulator and any other party to a regulation is not enforceable. There's no way you can get a conviction or to bring it out. If you had this regulation on your books, this would give you an opportunity to not discuss it and would give you an opportunity to tell any person that tried to talk to you about it that you're prohibited from talking about it. And so I think that, and one further point that I would make, you're a regulatory body, you're elected officials in a regulatory mode, and you're regulating a private corporations as opposed to SMUD, which is not a private corporation for profit. So that would be the extent of my remarks.
Okay. Thank you, Mr. Nelson. All right. If there's no other testimony before the body, we'll move to close the public hearing. Do I have a motion?
So moved.
Okay, we have a motion by Mr.
Do we have
Cox.
to open it again when we discuss this?
To close it, to close the hearing.
To close the hearing.
I think you can close the hearing now and discuss what response you want to make to the grand jury.
Yeah.
And
So-
then if the, depending on what you want to do with the ex parte rules, you can reschedule a hearing when you were ready to adopt them.
So it's been moved by Mr. Cox, second by Mr. Yee.
Close the
to
hearing.
close the hearing. Will the clerk please call the roll?
Aye.
Cox, Pratt,
Aye.
Castanis, Collin,
Yes.
Yee,
Aye.
Toby Johnson, Dickinson,
Aye.
Panay.
Aye. All right. My suggestion, members, and motion would be that we respond to the grand jury, we amend our letter, we amend it to, for, if you'll refer to your draft letter to the grand jury.
Could I ask a question? When's our next meeting?
June 3rd.
June 2nd.
So we really don't have time.
June 2nd.
I'm sorry, June 2nd.
I'm suggesting, in my motion, I move that we amend our response to the grand jury, taking out the provisions that were drafted for item 1, any provisions relative to item 1, that is recommendation 1, and we put in its place that the commission has reviewed a proposed regulations governing ex parte communications on these matters, and the commission is continuing to study this item.
Continue. Yeah.
Number 2, that we remove the wording relative to recommendation 1, and we leave it that legal counsel has discussed meetings requirements imposed by the Brown Act and the Government Code Section 54954 and all those after. If we've been briefed at the City Council and the Regional Transit Board, if we'd like an individual briefing for the Cable Commission, I suppose we could propose that as well. And then leave item 3 as it is, and that would be the recommendation and the letter from this body on this item. Is that clear?
Yeah. You did have a briefing here also on the Brown Act.
Yeah.
I thought we did.
Yes,
I can't
we've
remember.
already
I've had so many of them. I
addressed
just.
that. The only
Okay.
other staff administrative aspect of this would be, Mr. Chairman, if you would consider concluding your motion that the commission delegates to the chair authority to execute the document at his discretion and transmit the document.
Transmit it. Well, I had assumed that would be part of it. I obviously have to sign this, so. But I wanted to get clear what was going to be in the letter, and that would be specifically it. Is there a second to that motion?
Second.
The second by Mr. Cox. Discussion on the motion?
Yeah, if you're willing to put some expected action date on the item with respect to the ex parte, either up or down, frankly. But just saying continuing to study, I mean, that could go off into space forever.
I would
if you
agree
put,
with that.
If we said, I don't know, next month or
60 days?
60 days, I mean, then
Okay. 60 days would be fine. I'd be amenable to that, to relook at this whole issue. Mr. Cox is amenable, so the mover and the second is amenable. Any other items on this? Okay. Everyone, staff is clear on the draft of the letter and how we're going to remove those sections and put different sections in. Okay. If there's no other discussion, all right, the clerk please call the roll.
Cox.
Aye.
Pratt.
Aye.
Collin.
In the spirit of a compromise, as long as we have a date, bring it back, yes.
60 days.
Yee.
Aye.
Dickinson.
Aye.
Panay.
Aye.
Motion carries.
Okay, the motion carries. We'll move on to item 2.
Mr. Chairman, if you could,
Yes.
is there any direction of staff in how to respond to you within your 60-day time frame, or any expectations of staff? The only, in my notes, I've heard some concerns. The only specific recommendation we have is that there be some range of degree of penalties in section B on page 3. Is there any other direction of staff in in terms of the draft prepared for you.
Well, I think there's been a number of questions asked. There have been questions asked relative to the body as an elected body, 100% elected body, and relative to appointed bodies. If there's any distinction in law, or if there's any distinction in how other bodies do it, or if other elected bodies, besides the judicial body being one person, or in the case of appellate matters, more than one judge. Then there's been the discussion as well, and perhaps a little brief on other bodies that may have ex parte regulations and how they function. There's also been the discussion on constituency contacts. If there's any thought by staff on if that would be completely inappropriate, if a constituent talks to us about it and you can't get the constituent to stop, correspondence from constituents, I think those have to be looked at as well. If staff could prepare some briefing on that. I don't know that the body wants staff to move forward into the policy realm of suggesting any other things in that way, but the body could come back and look at those types of questions and answers. Ms. Collin.
No, I was just going to indicate that it seemed to me that of the substantive issues that were brought forward, if you really believe that we ought to have an ex parte communication, then we really should be looking at what's been drafted and what changes you might want to see drafted in that, not go back over a lot of the issues that are policy issues on whether you want to do it or not, because those are policy issues. I think what they want is, is there anything in these specific drafting that really is causing the problem? I think the biggest problem that I have heard, because we haven't done this before in terms of really having a notice that now we're in an enforcement proceeding, or now we're in a regulatory, strict regulatory proceeding that we're going to prohibit these type of communications. The biggest concern seems to be on the part of elected officials are really the constituents. The biggest concern is not the franchise making the contacts. Those contacts probably will not be made by that body once that notice is given. I respect what Darby has to say, that if we adopt this and if it's given, then they simply will not make the contacts during that time. So I think the bigger worry that we have to look at is really what to do about constituent mail and constituent phone calls. And I don't think anyone is thinking that there ought to be penalties for that. At least I've not thought of that. I do think that it was good to put in there they could be immediately transmitted to the director so that everybody has access to the concerns being expressed, and so that all of that will be on the public record when we go into the public hearing. And I think that Roger's comments about the remedies is probably true. It is so broad that I don't know if there's any way to change it. But you know, if there is, and good attorney minds want to think about it, that's fine too.
Okay. Any other points from the commission? Okay. Seeing no other points, we'll move forward on to item 2.
Mr. Chairman, members, going back to November, requested Sacramento Cable Television to provide the commission with its affirmative action plan and affirmative action documents. Last month, he directed that the city's affirmative action officer review that plan. Today, Mr. Ken Fleming is here with his report back to you on his review of Sacramento Cable's affirmative action plan. First, I'd like to say that it's my pleasure to work with Mr. Fleming over the last month. We hadn't worked together before. In fact, we hadn't met until your direction to seek his advice. He's worked very hard on our project. I apologize to him for pushing him through a couple of deadlines to meet our schedule, and that a couple of typos got through in his filing with you. We do have an updated version for you without the typos. With that, I'd like to have Mr. Fleming make his presentation to you on his report.
Commission Chair, members, and staff, good afternoon. My name is Ken Fleming. I'm the city's affirmative action officer. I wish to present to you this afternoon my review and assessment of the affirmative action plan submission of Sacramento Cable. My findings were contained in an April 27th letter to the executive director. I'd like to briefly discuss some of the highlights of that report. The areas covered within the report basically deal with areas that were determined to be inconsistent with traditional requirements are inadequate. There are many provisions of the plan, however, I think that are very positive and good. However, in an audit, we generally look at the areas of deficiency, so I will be dealing with those issues. The review was performed considering the traditional EEOAA principles, applicable federal state regulations, as well as Section 575416 of the amended Cable Television Licensing Ordinance and the regulations and ordinances of the city and county. Our review, again, comments are directed toward areas of the plan that are inadequate or not in compliance. And based on that review, we determined that there were 8 significant findings. Those findings are as follows. If I could have the slides.
I rode 22 miles.
Slowly it begins to work.
A little technical difficulty here. Let's see. First finding was that the policy statement was not in compliance with the licensing ordinance. The policy statement of any affirmative action plan is a crucial document to the success of that plan. It basically publicizes a particular entity's commitment to affirmative action, and it forms the basis for the community's expectations of that agency. The Sacramento Cable Television policy statement does not conform to the letter and the spirit of the commission ordinances. There are several protected categories that are required by the ordinance and applicable regulations that are not included within the policy statement. Those particular categories are marital status, ancestry, mental disability, medical condition cancer-related. In addition to that, the California Government Code requires that employers inform employees and applicants that physical disability coverage also includes HIV and AIDS. The second finding was that the assignment of responsibility should be amended. The person ultimately responsible for affirmative action in any organization is the chief executive officer. The SCT plan does not include responsibilities that are directed for the chief executive officer. At a minimum, we are recommending that the plan should be amended to indicate that the chief executive officer is responsible for providing support and staffing to ensure the full execution of the affirmative action plan. The third finding was that the job groupings appear to have been inappropriately developed. Job groupings are basically combinations of job titles that represent work in a closely similar nature, which have a very similar job and salary range. Such job titles are merged when the number of incumbents within a particular category are too small, or when the number of titles are too large for separate analysis. In either case, it is permissible to merge these titles if they are truly similar in content as well as pay level. The STC plan does not indicate the criteria under which the job groupings were developed. In some cases, using traditional employment philosophies, it would appear that some of the job groupings are not homogeneous in terms of pay and content. It would appear that some of the positions, particularly listed in the officials and manager category, might be classified in other categories. When job groupings are not assembled, it sometimes has the ability of providing a picture of a particular work group that is not totally accurate. Depending on the workforce composition within a particular job category, misgroupings may provide a distorted view of the actual representation of women and minorities in a particular group. In particular, in our review, there were a couple of titles that seem to be more appropriately categorized as professional positions such as trainers, utility coordinators, purchasing agents. Those types of positions generally are not considered official and manager positions. But again, because we did not have specific information, we could not make an accurate determination. Our fourth finding was that the availability computations are not in compliance with the Commission's ordinance. It would appear, based on the applicable regulations and ordinances, that the Commission has mandated that goals be set to achieve a workforce which mirrors the population of the residential community of Sacramento. Within the SCT plan, it states in Section 5 that in order to determine the availability of minorities and females in each job group, Sacramento Cable Television analyzed the population as a requirement by revised order number 4. If we assume that this particular order is applicable, it does not mandate, in fact, that the employer has to use any particular criteria. It only says that the contractor, a federal non-construction contractor, must consider the 8 factors when determining availability. There is no requirement that any minimum weight or any weight at all be given to any particular criteria. It would appear from our assessment of this particular analysis that the analysis performed by Sacramento Cable assigned great weight to factors other than population. Based on the Commission mandate, significant weight should have been assigned to the area of population. The 5th finding was that minorities are underutilized to a far greater extent than the plan indicates. Based on the finding in our previous finding that the availability computations were not computed correctly, the comparisons of availability and actual utilization would have reflected a greater number of categories with underutilizations. I will show you some comparisons that we prepared. I have it overhead, please. Based on computations within the plan, as well as computations using a peer formula, providing a greater weight to population, and a second one, the same formula, however, applying the rule of 1. And applying the rule of 1, that's simply a process where you would look at a particular job availability, comparing it with the utilization within that category, and if there was an addition of 1 person to that category, if it would still be underutilized or at parity. As you notice, for the official and manager category in the SCT analysis, there were no areas of underutilization. However, again, using the Commission standard, there was underutilization in 3 categories using a peer standard, and in 2 categories using the rule of 1. Same principle looking at the professional category. Again, the Sacramento Cable analysis showed no underutilization. Again, applying the Commission standard, there was an underutilization in 3 categories, and the rule of 1, no underutilization in any categories. Within the technician area, again.
Ken, what does the NA mean?
NA means not applicable. Basically, when we did our particular analysis, we did not look at females. In the first column, perhaps I should explain each of these columns for more clarification. The first line of the column basically indicates the composition of that particular category numerically within the Sacramento Cable workforce. The second is the percentage of utilization for that particular work group within that category. The third line basically indicates the availability, which is the requisite number of persons within the workforce possessing that particular skill set. And the final column basically would indicate if they were underutilized or not in that particular category. An NA meaning we did not analyze that particular area, a Y meaning yes, there is an underutilization, and N meaning there is not a underutilization.
Ken, can you clarify rule of 1 again?
Yes, the rule of 1 is a process by which if you would look at a particular analysis of availability toward the workforce, if you would add 1 person to the number of persons within that workforce, would it change the representative percentage to make that particular category at parity, or would there still remain an underutilization? So basically we use that particular rule to determine if there is a significant underutilization, because if 1 body would change that, then we deem it not to be a significant underutilization. The fallacy with that process, however, again, is if you're dealing with a category that has a relatively small number of representation, one number can change it. For instance, in the professional category, there are only, I believe, a couple of people that are employed, a total of 2 people employed in the professional category. So any change in that category would take a particular category out of being underutilized and would require no goal.
Where are you adding 1, 2? To the composition?
To the composition, right. Okay. 1 person to the overall workforce.
I got you.
Okay, one last question, so that when you have the NA, meaning not analyzed, there was a reason why you didn't do that, or?
In our analysis, we did not analyze female, and the reason for that was we were basically looking at minority. We feel, and we will speak to that a little later in our report, that the commission ordinances are not really clear in the sense of dictating that population be the basis for comparison for females. It is our reading that that is the case for minorities.
Okay.
Okay.
In the sales category, again, the Sacramento Cable analysis indicates an underutilization for females, but for no minority groups. And the analysis using the strict commission standard, there is an underutilization in 3 categories. And applying the rule of 1, there also remains an underutilization in 3 categories. Within the office clerical area, the Sacramento Cable analysis indicates no underutilization. Within the same category, using the strict commission standard, it shows underutilization for Asians and American Indian. Applying the rule of 1, only an underutilization for Asians. Within the operative category, again, the Sacramento Cable analysis shows an underutilization for females and for Hispanics. In the analysis using the commission standard, there is an underutilization for Hispanics, Asians, and American Indians. Applying the rule of 1, no underutilization. And the final category, laborers. Again, the Sacramento Cable analysis shows no underutilization. Looking at that same comparison using the commission standard, shows an underutilization for blacks as well as American Indians. Applying the rule of 1, no underutilizations. Overall, the Sacramento Cable analysis would show that there is an underutilization of females in 3 categories: the technician, sales, and operative. And that there are underutilizations in certain categories for minority. However, if you would look at that same comparison using the strict commission standard, you will notice that the number of areas that are marked Y where there is a underutilization are greater. Final look at that same workup applying the rule of 1. Again, the number of persons who are categories that show some underutilization are somewhat greater. If we go back to the slides, please. Based on the findings that availability computations are not in compliance with the Commission ordinance, the workforce availability comparisons do not reflect the full extent of minority underutilization. And primarily, we have found that our analysis using the strict application of the Commission standard shows an overall underutilization in 3 categories, applying the rule of 1, 2 categories. The 6th finding is that basically the manner in which utilization was determined resulted in lower hiring goals and for minorities than if the Commission guidelines had been used. Additionally, we found that the goals established were not specific and measurable. Goals and timetables are acceptable under the Constitution and laws of the United States so long as they are reasonably related to a legitimate purpose of achieving equality of employment opportunity. To be appropriate, goals should be significant, measurable, and attainable. They should be specific and planned with timetables for completion. In virtually every category where the Sacramento Cable plan set goals, they were simply designed to maintain employment ratios which were said to be adequate, either overall or for an individual group. In no instance was there a specific goal cited or reasonable time frame by which a program would be designed to overcome that goal. If the Commission guidelines had been followed, there would have been a need to set additional goals in certain areas that reflected unutilization. Additionally, it was our determination that the plan failed to set specific and measurable goals for identified underutilization.
What are the reasons for that?
The seventh finding dealt with the action-oriented programs, and we found that the action-oriented program component was not sufficient to enhance Sacramento Cable Television's affirmative action efforts. Affirmative action programs generally should be designed to do more than just passively permit equal opportunity. They should reach out into the community and draw into the workforce those previously excluded. The actions and efforts listed within the Sacramento Cable Plan simply cited prudent personnel practices. They did not address all the areas that were identified as problem areas. Action-oriented programs are generally corrective measures that are channeled to effectively eliminate barriers to effective affirmative action. They should be specific with definite actions, and each step should have a person that is assigned the responsibility for implementing that particular action-oriented program. They should indicate the desired accomplishment as well as a timetable for completion where appropriate. The action-oriented programs in the plan do not appear to be adequate to correct identified problems or to significantly enhance Sacramento Cable Television's affirmative action efforts. Our final finding dealt with the harassment policy. It is our opinion that the harassment policy is inadequate. The Sacramento Cable Television harassment policy in its entirety lists two sentences. They read, Sacramento Cable Television maintains a strict policy prohibiting unlawful harassment. This policy prohibits harassment in any form, including verbal, physical, or visual harassment. This policy does not encourage individuals to seek internally redress for their problems. It gives no indication who or how they should file a complaint. The ramifications for persons who indulge in prohibited behavior have also not been included in this particular policy. It would be advisable to include also within this policy coverage of acts of discrimination based on some other protected area. There were some additional areas of concern that we found that basically the information was inadequate to assess. Those dealt with the applicant flow and hiring data, part-time hiring, the training components in terms of who and actually what type of training individuals were allowed to participate in, as well as the number of discrimination complaints that were received. Based on our review, we are making a recommendation to the Commission that we undertake a full on-site compliance audit. Such an audit would allow us an opportunity to work with Sacramento Cable to enhance the plan, to make it truly proactive and one that would have the desired effect. In addition to that, it may be advisable for the Commission to take another look at the ordinance to revise it. There might be some issues that are not totally clear in the sense of directing the franchisee as to what is expected in the area of affirmative action. It would also be advisable to require the franchisee to submit an AA plan that is in conformance to that particular ordinance. If there are any questions, I'd be more than happy to respond to those.
Okay, Mr. Fleming, thank you.
You did an excellent job, Ken.
Good job.
Any questions from the Commission?
Yeah.
Yes, Mr. Yee.
Ken, I assume that that recommendation that you made at the end is that you will get together with Sac Cable to discuss the findings and recommend or advise them as to how they can improve their policy?
Mr. Yee, working together with Ken, I'd like to propose or to replicate his recommendation to you, having reviewed his report, and would put before you a recommendation such as this, that you authorize the on-site the audit as per his recommendation. But first, we ask over the course of the next month, or say through till maybe like June 15th, that Mr. Fleming work with and meet with Sacramento Cable officials to narrow the scope of the audit by Sac Cable providing responses to the findings he's mentioned here. That Mr. Fleming's discretion, having narrowed the scope of the audit, provide you with in letter format, effectively an audit plan, which would lay out what areas he would like to move into and look into, if any, the timeline and costs which would be associated with that. So that we provide at least 4 to 6 weeks for management level dialogue, and I'd like to be included in that as well.
Yeah.
Before we move to the on-site phase.
Okay.
Yeah, Rich, I look at this audit as a two-way street. You know, it tells the commission what's happening out there. At the same time, it also allows Sac Cable to improve their in-house, because you know they go merely on their way assuming they meet all of our conditions.
Right.
But until someone takes a look at it and say, hey, wait a minute, you're out of line here.
The city has a tremendous resource in Mr. Fleming. I'd like to make the bridge that he can work with Sacramento Cable under your auspices to come up to the levels that are expected in your ordinances. And as Mr. Fleming just mentioned, if the result is that we need to adjust your ordinances, we'll bring those back to you as well.
Okay. Any other questions from commissioners?
Is that within
Ms.
the
Collins?
same time frame?
I would expect that the time frame that would come out of Mr. Fleming's audit plan, say by the 1st of next month or at some point that he feels reasonable, would include in the timeline a report back to you on
strengthening our own ordinance.
Right. Okay. The on-site and restructuring your own ordinance if necessary. I think this is probably a 60 to 90-day project, if I'm not mistaken.
I would agree. Okay. Any other questions? Okay, we have some testimony. Thank you, Mr. Fleming. Stand by. We may have another question for you. Penny Costa. Ms. Costa?
Good afternoon. I just wanted to take a minute to broach this topic with you and say that I have had some discussions with your executive director about the affirmative action report submitted by Mr. Fleming, and I have met Mr. Fleming this afternoon. And Sacramento Cable is happy to meet with Mr. Fleming. We'd like to meet with him and talk to him about the specific issues he's raised and see how we can go about accommodating him consistent with our obligations under what you know is the whole panoply of rules and regulations that apply to our operations here. In particular, I would commend Mr. Espasto's recommendation that we have a period until, I think you said about June 15th, where we could meet with him and have a dialogue about what the concerns are and our approach to them, and see what it is that we can resolve and address before the issue of the specific on-site audit is finalized.
Okay, that sounds like a good plan. Any questions from the commission?
Nope.
No question. Okay, well, that sounds like a good plan. Thank you, Ms. Costa. Any other member of the public like to speak on this item? Okay. So, the will of the commission on this item?
Accept the staff recommendations.
Second. Okay, it's been moved and seconded. Moved by Collins, seconded by Dickinson. Any further questions? All right.
Dick.
No other further questions. Clerk, please call the roll.
Cox?
Aye.
Pratt?
Aye.
Collin?
Yes.
Yee?
Aye.
Dickinson?
Aye.
Panay?
Aye.
Motion carries.
Okay. Item 2 out of the way. We'll go to item 3.
Mr. Chairman, members, we did spend several days with the FCC in San Francisco understanding the new and revised implementation of the FCC's rate regulations. In summary, back up a year ago, I explained to you that the old format was one based on essentially heuristics. There were 3 key factors that were used by the FCC in making its rate determination. They've now expanded that to a list of a number of factors. My recommendation to you is that we secure the assistance of a consultant. I'm recommending that you retain on a sole source basis a firm called Public Knowledge. You'll recall, first off, the principle of Public Knowledge is an old face to you, Jay Smith. He used to be with Touche Ross. I'm going to ask that the consultant assist us in making the rate determinations. And the primary, one area that I'd like to show you that so much hinges on key factors of the analysis that I'm sorry to say that we don't have a way to verify internally. I was going to show you this chart, but let me just give you the specifics. I've talked with Mr. Smith. We're comfortable on the outside that this is a $10,000 project. I will manage his time as carefully as possible and focus him on as few issues as absolutely necessary. This includes his time to make one presentation before you in this rate determination process. If we have the overhead for a second. The FCC provided us with a packet of forms. I have to compliment them from a analyst perspective that the new packet of forms is available to us now in spreadsheet format. So for the cable operators throughout the country, they can make their presentations and determinations using Lotus, Excel, etc. For us analyzing it isn't quite so simple. The one factor I've highlighted here is one that I think hopefully will give you a sense of the issue we have to make a determination on. There's item 4 on worksheet 4, customer equipment installation percentage. Historically, cable operators have not kept their accountings, their books, in a way that provides hard data on what portion of their total assets, total operating plant and capital, address customer issues. The example we'll use is a vehicle, a 1992 Econoline van that is at one of your homes making a customer service action, an installation or repair. The the technician's beeper goes off because there is a system outage on a system component rather than on a specific customer component. The company, by using this one calculation, makes a percentage allocation of all its assets between those two categories, what is system and what is customer. I feel we need the help of a consultant who's doing 30 to 50 other analyses in other jurisdictions to tell us that the determinations made here are ones that we can rely on. Again, the importance becomes that as you go through this second process now and make determinations, these are the long-term foundations for which all other adjustments will be made. This one factor is very, 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 very critical, and that's why my recommendation is that you secure the limited resources of Mr. Smith.
Okay. Thank you, Mr. Espasto.
Thanks, Rich.
Questions from the Commission?
No, I would move the recommendation.
Second. It's been moved by Ms. Collins, second by Mr. Yee. Is there any testimony from the public? Okay, seeing no one coming forward, we'll call the roll.
Cox.
Aye.
Pratt.
Aye.
Collin.
Yes.
Yee.
Aye.
Dickinson.
Aye.
Panay.
Aye.
Motion carries.
Okay.
Item 4 is a recommendation from staff that you place on your agenda in June a notice public hearing to amend the customer service regulations. It's been over 2 years since we've addressed those or made any changes. There's one I think is very easy to support, and I would believe be an oversight in the beginning. That is a request by Sacramento Cable that Easter Sunday be added to the list of holidays. Separately, I'm recommending that you consider and invite Sacramento Cable and your other cable operators to comment on a proposed limitation in the customer service regs on late charges. This is when we get past the general issue of telephone complaints, which by the way, we've had historically some telephone complaint problems of late. Sacramento Cable has reported, and we agree that their telephone statistics are well within our standards now. Late charges is an issue of very important, very heavy concern of your constituents, of the subscribers. Right now, the disclosed late charge policy of Sacramento Cable is $5 for payments not received by the due date. As you can see in the staff report, I've looked at some other entities, some other providers of service in Sacramento, and assessed their practices, and proposing to you regulation language at this point, not so much to lock it in concrete, but as a process we've used before to get responses from Sacramento Cable and in this case Cable America or PAC West as to how they would like to make the language look. It's my sense that you need to actively consider a regulation on late charges because, for example, as I've used here, a $5 charge on a $10.50 service implemented on the due date is viewed by many as excessive. And as you can see, many other jurisdictions and towns, as I've mentioned, have eliminated late charges. Again, the recommendation for today is that you schedule a hearing to discuss this in more detail at your next meeting and invite Sacramento Cable and others to respond by May 18th. The reason for the May 18th response is to provide us some time to dialogue back and forth on the issues.
All right. Mr. Dickinson?
Thank you, Mr. Chairman. I'm glad to see this proposal, particularly on the late charges, coming forward. In fact, it was something that I was going to bring to the commission myself, but
your bill was late?
Great minds seem to move in parallel lines here, I guess, or something along those lines. I think it's of interest that the state of the law in this area reflects that there's a distinction made for a long time in the law between what are called liquidated damages and penalties, and where the calculation of what will be owed as, in effect here, a late charge or liquidated damages has some reasonable relationship to the actual cost incurred, then that is legal. But where it exceeds that or has no reasonable relationship, the law considers that a penalty and an overcharge. There's been significant case law in the last couple years that have cost some banks several hundreds of millions of dollars in this area for the late charges that they have imposed, which have in effect borne no relationship whatsoever to their actual cost that has been incurred as a result of customers being late. And it simply amounts to a windfall for that business which charges the late fee. So I think this is entirely appropriate in lieu of the 5% amount or $5. I hope that the analysis that comes back from Sacramento Cable will give us some idea of what their actual cost is with respect to this issue, so that the regulation that we might adopt would be consistent with the approach taken by statute and case law.
Could I also ask?
Ms. Collins.
Yeah, my question would relate to the fact that the late charges are set up, but my understanding is you are paying for a service before you receive it, correct, with Sac Cable? So that also is a very interesting aspect of this, that really you're paying first before you receive the service during the month. And so I don't know quite how to relate to that either. That is very unlike a lot of other situations where you receive the service during the whole month and then you pay for it.
Now, in developing the customer service regs 2 years ago, and if you recall, we didn't negotiate those. We discussed those at length for 6 months. What we tried to do was establish a timetable in which the subscriber had advance paid for half of his billing cycle, and then the other half, his billing cycle overlapped the payment due date, so that we split the difference. If you'd like us to look at that further, we'd be glad to. Where it gets difficult is a portion of the cable company's billing is routine every month, and a portion of it varies by individual selections. It gets very confusing for consumers if we introduce a lag time into that. And so we thought this was a reasonable compromise to allow the cable company to close out and keep things current, in a combination of many factors. But if Sac Cable is willing, I'd be glad to discuss it with them.
Yeah.
Okay, Mr. Yee.
Yeah, Rich, I was intrigued with this item because being a private practitioner, I always like to get my bills paid on time. And I look at this as what is the cost, like Mr. Dickinson had said, in processing a late charge. I know that in prior instances, I have received late charges on some of my credit cards, and I get upset because it's not paid on time. So I instruct my employees to make sure they're paid on time. Just the process of having to pay a late charge, I don't like it, so I pay my bills on time. It's an incentive for subscribers to pay their bills on time. I don't think they really should take advantage of it. Now, if we go 5%, as this item proposes, on a $10 bill, it's 50 cents. I'm not so sure whether a company can handle late charges at 50 cents. I don't know. Maybe they can.
I believe what Mr. Dickinson is saying is that the current case law, and Harry can back me on this, looks to what the actual cost is, including the cost of money.
Right.
There is, and that needs to be looked at and surfaced. As I understand from my quick review of one of the sites, giving computer services and everything else, the actual cost probably isn't $5, however. On a $10 bill, we're up high. So that's why we'd like to get into it and bring it to what is the appropriate case law, regulatory-based balance.
Well, look at bank charges. I mean, that's ridiculous. Of course, I don't want to be charging 18%, but on the other hand, 50 cents. Maybe they can get by with 50 cents. I don't know. It's I certainly can't do it in my practice.
Right. Well, I assume your bills are a little higher than the cable bill, Mr. Yee. I do. I sympathize with you. I'm in private practice too. I just hope my clients pay. Forget the penalty.
I hear that. And they delay their payment even further. Tell me about it.
We have all been there, Mr. Yee. Well, any other comments from the commission on this item? Yes, Mayor.
I think Mr. Dickinson stole my notes somehow from the other side of the room. But in our little city, every item like this has to be supported by actual cost, the documented cost. But I would raise or say that it begs the question, what if the costs exceed $5? Mm-hmm. But we want to know, I guess, huh?
Well, it's a pretty big bill then, but I guess.
Well, whether it's $10 or $110, the cost to
process,
late notice and process and all is going to be the same.
Yeah.
I would think.
Yeah, but I'd be skeptical and surprised if it amounted. I mean, in the context of the bank charge litigation, the charge for transacting business that comes in late, it turned out to be very small when the banks were actually forced to unbundle their costs and assess it realistically.
Okay. Any member of the public wish to speak on this item before the commission? Mr. Gruber, come up and say.
When Mr. Gruber come up, I'd like to know how much time that the subscribers have to pay their bill before they're late.
Don't have the exact number of days. I would point out, though, that there's a common sense of frustration among some customers who don't like the late charge regarding paying in advance. And as it was pointed out by Mr. Esposito, in fact, even with the telephone company, a little-known fact is that you pay your phone bill in advance for the month because that's what the phone company knows that you owe, and the charges that you ring up, just as with our pay-per-view charges, are subsequently charged the following month. There are very few entertainment services, whether it's Blockbuster Video or United Artists Theaters or Bill Graham Presents, where you don't pay in advance before you get your entertainment. But we do look forward to providing extensive documentation and data to the Commission on exactly what our costs are, in addition to the extensive costs of retrieving equipment and in collecting for the service that, of course, is not a necessity, and some people from time to time don't pay their bill. We've also discussed with Mr. Esposito briefly the fact that occasionally with the customer service regulations there are some elements that relate to how we can be as responsive as possible to our customers with necessary notification, programming changes, whatever. And our business has changed so much, and our programming issues and rates and other issues have been through so much change that we may have a suggestion or two ourselves as to how we can slightly modify the customer service regulations in a way that would allow us to be more responsive, and we'll be providing that to Mr. Esposito in the next week. So we look forward to providing you all with that documentation and discussing it with you next month. Thank you.
Thank you, Mr.
Mr. Yee, the customer service regs are crafted such that the payment due date is 20 days from the mail drop date.
Okay. 20 days?
20 days.
Yeah.
That usually, in normal routine practice, that gives the subscriber 17 days.
Okay.
Okay.
Just to add, what is
mail
one of the triggers, though, the day it's mailed, is that Sacramento Cable invokes its late charge penalty at the due date or shortly thereafter. And in the surveys we looked at in some of the other case law, there is a lag time, a greater lag time after the due date before the penalties are invoked. And that's one of the things here we'd like to discuss.
But the payment is logged in as they get it, so they know exactly when Sac Cable received the payment?
It's an issue that I have some question on. We have, and again, within within our structure, I have to assign some statistical things, but we have a couple of complaints in the office where, of late, where a late charge was assessed, but the subscriber can show that his check was cashed before the due date. So we've got some things to work through here and look at. And the invitation was extended to Sac Cable generally. There was a letter on the Easter Sunday issue, and I did call Brian and call other directors at Sac Cable and say that there are other aspects of the customer service regs you would like to look at. Now's an appropriate time.
Well, let me ask this question. Was that particular case resolved?
It's in the process of being resolved now. I believe it was resolved, and the late charge was waived.
Okay.
One thing I have to say is that Sac Cable has been very accommodating to subscribers who have received a late charge and who call and question it. It's 99% of the time it's waived. From our perspective, and the complaints we have are, what about the subscriber who doesn't have the time, won't take the time, or can't get through on the phones at a particular time to get that late charge waived? And that's what we're looking at.
But we can't speculate, though.
Right.
All right.
No, but I think from what we have heard, they have been very responsive to waiving the late charges. And I've heard the same thing in terms of when people call in and they've got good legitimate reasons for why they feel that they want to challenge it.
Well, I do want to just offer a thought here that I consider it a problem when you have differential treatment because someone happens to complain and someone else doesn't. In the auto business, it's called secret warranties, where someone who happens to complain where the manufacturer has told the dealer, we'll pay for that if the person complains when it's beyond the warranty date. That's in the written warranty, but it's someone who comes in just says fix it, gets to pay for it. I mean, if there are going to be late charges, then there ought to be late charges. If they're not, there shouldn't be, and it shouldn't depend on whether someone has the time or the assertiveness to call and say, please don't do this to me.
Consumer protection.
I think we're going to learn an awfully lot about law.
We're going to learn a lot about consumer protection from our consumer
Mr. Cox
protection
is
counsel.
concerned about the tutorials here.
No, I think that your point is a very good one, though, that, we do have to look at this issue, and I'm willing to do that. I'm just
He
saying
won't
that
complain when that law degree is hanging on the wall in his office, though.
Okay.
Is he taking
if there's no other...
doing it by correspondence.
On a daily basis.
The other situation is you can do it by osmosis, just sitting next to Roger. 4 years later, I'll be able to sit for the bar and pass.
And my insurance rates will go through the roof.
only if you retain Mr. Cox.
My point precisely, Mr. Bonnet.
All right. If there's no further discussion, no public testimony, no more public testimony, what's the will of the commission on this item?
Move staff recommendations.
Moved by Mr. Dickinson, second by Ms. Collin. Would the clerk please call the roll?
Cox.
Aye.
Pratt.
Aye.
Collin.
Yes.
Yee.
Aye.
Dickinson.
Aye.
Panay.
Aye.
Motion carries.
Okay, item number 5.
Members, I have 7 quick items for you on the staff report. I'll go through very quickly. Your general counsel RFP has been released. You have paperwork as far as the spread and breadth of the notice. We've had right now 63 requests for RFPs and 7 responses. The legislation, for those of you who went on the capital trip, I provided you with some background paper on the federal legislation. That is now gearing up. In fact, as of today, legislation on the Senate side, hearings in the Senate side are beginning on telecommunications issues. I have before you a recent League of Cities news release on some of the local government concerns and what the League and NATOA hope will be introduced on the floor about protecting local government, especially streets and rights-of-way. At the state level on legislation, per the policies adopted, you adopted last month on legislation, we provided support to a disclosure and privacy bill that did get out of committee, and I understand now that with some from the legislative staff, the cable industry is supporting now as well. Another bill on a statewide council on cable television. It did get out, but I don't believe its prospects are great. On the Senate side, there's a bill that we're beginning to analyze, and I'll update for you. It's a cable industry bill that says if telephone company is allowed into the cable market, cable companies are immediately allowed into telephone market. That meets with some of our broad policies on competition, although the bill doesn't address issues like franchise fees, et cetera. So we'll probably be seeking some clarification on that. Point 3, the FCC released last night its rulemaking on equipment compatibility. There was not a copy available this morning on their Internet Gopher. I will secure that as quickly as possible and compare the FCC's decision on equipment compatibility, that is VCRs, converter boxes, with the recommendations that this commission filed through its engineer. There's a memo before you on item 4 that the Sacramento Cable suit against this commission regarding the Cable America license was decided in the commission's favor. It's probable, if not likely, that Sacramento Cable will appeal. The judge provided some important rulings on your behalf. There's another trial, a Coleman trial, which is the class action suit against Sacramento Cable. That is now in a quasi-penalty phase. The judge has ruled against Sacramento Cable in all aspects, as I understand it. The reason for mentioning it to you is that I've read the judge's transcript. I don't have the ruling yet, but the judge has made a preliminary conclusion that your cable television franchise has been violated. When that case is complete and the process is committed to writing, I'll be referring it to counsel for review. The November enforcement action on traps is proceeding. There have been some schedule difficulties with getting the lawyers together, but Sacramento Cable is on track with that. I met and spoke with Penny Costa this morning about it. Item 6 is that your commission is embarking upon the biggest package of election forums since I've been in Sacramento over the next 3 Saturdays with significant replays. The outside media are giving it some attention. We are maximizing our playback time in our effort to educate your constituency and others as much as possible. And lastly, if you recall, we have 2 things going on administratively. One is that the county auditor controller is conducting their biannual audit of our offices. It's routine at this point, nothing remarkable to report to you. I'm asking them to hold the audit open as they finished last year and the year before now. I'm asking them to hold the audit open, continue and report back to you in September so that we can close out this year as well. It's just an efficient move. Why bring the auditors back in a few months? Let's wrap it all now. I'll have for you, last year when you approved the grant agreements for the grantees, we modified the process such that the grantee budgets were presented to you along with the operating budget for this commission. The due date we agreed to was May 10th. So I will be assimilating or bringing the grantee budgets together with the proposed operating budget, and we'll have that out to you by the end of next week, if not the beginning of the following week, for your consideration in June. And that's the staff status report. Any questions? I'd be glad to respond.
Okay, any questions for the executive director? No questions. All right, we'll move on to the next item. Item 6.
It's the grantee status reports, and
okay.
You have a few tags.
We have a few grantees in the audience, I see. Why don't we start?
Jay Thompson as the first.
To come on out to that panhandle part north of Twin Cities and let us take perception level was wrong. It's not all flat, all ground. And so consider it. Come on in the morning, we'll have coffee and donuts or something. We've got a real nice, big, comfortable 4-wheel drive. We'll take you out there and show you.
Good afternoon. I'm Jay Thompson, board member of the Sacramento Educational Cable Consortium. Dave Vaca, the chair, has asked me to express his apologies for not being able to be here. He had a must-attend meeting in his district office. Our report today is an overview of some of the many activities of the past year as seen last week during our 5th annual award night by approximately 300 of our strongest supporters who participated in the event. Since you all had other pressing commitments and were not able to attend, we thought you might enjoy seeing via videotape a few highlights of the evening. Now, the SECC Award Night is our opportunity to celebrate another year of accomplishment and local production, and to honor teachers, students, and supporters of educational instructional cable. Also included in the festivities last week was the 2nd annual Student Educational Video Award Competition, or SEVAs, as they are affectionately called. The SEVA recognizes the best of local student educational video production. This year, Sacramento Cable Television co-sponsored the SEVA competition, and we thank them for their support. We'll now play a short videotape, which will open with a recap or montage from video productions, some by students and some by instructors, from the 1993-94 SECC school year. Then this will be followed by 2 minutes of highlights from the SECC 5th Annual Award Night. If we could have the tape, please.
We had a lot of people participate.
Discover the world of educational cable.
Take a seat. We're going to have a little time to recognize each other. I think it's a great time. My name is Steve Wenlock. I'm the Director of Elementary Education for the Elk Grove School District. I'm also a past recipient of one of the Sacramento Educational Cable Consortium Awards, which I'm really proud to say it sits very nicely in my office. And I know that we're all excited about being here. It's like the Academy Awards. And I want to applaud all of you students. You look beautiful and great. Let's give them a nice hand.
I think like the really exciting part of this program. It's what it's really all about. It's about kids, and boy, am I lucky to be the person who's going to hand out these awards. I'm excited. Sacramento Cable is just really pleased that we could be a part of this, and we hope that someday, say maybe the year 2000, we're going to be running programs from these kids on our cable channels. One of the things that we all know that's happening is the only kind of news that we hear is bad news about bad kids doing bad things. Well, tonight, there's a lot of extremely good examples about let's say great things, doing wonderful things, and it's doggone time we recognize them, and we're here to do that. And that award is going to The Road to Recovery by Priya Patel from American River College.
Hi, my name is Priya Patel. Thank you for joining us today as we talk to 4 recovering alcoholics who are here to tell us their battle against alcoholism.
Great. Incidentally, Priya also was the winner of the College Talent category, so congratulations to both of you.
I just want to say that after watching those programs, you know, when we all hear about that TV isn't worth watching, they're not watching this, are they? It's great. I'm just very impressed with what the students have done, and I think there's a real future for TV. What do you all think?
Cable provides a unique educational resource to the Sacramento community. During the past 9 years, we have seen a remarkable growth in this valuable resource, and we recognize that many players work together in seeing Sacramento's vision become a reality. Tonight, we recognize a few of those outstanding organizations that contributed to educational cable here in Sacramento. The Sacramento Metropolitan Cable Television Commission has been a longtime supporter of the vision of educational cable in Sacramento. Over the past 6 years, the Cable Commission has provided a majority of the funding for SECC activities. SECC appreciates the continued interest and support of the Cable Commission.
Josh, if you could come down. If you refer to the program you have just received by Liz Rhodes, our executive director, you'll notice that we honored those organizations that contributed significantly to SECC and its educational activities. Now, one of those organizations and a key supporter of all of our activities is this commission and its members. We thank you for your belief in the value of cable for educational instructional purposes and your continued commitment to SECC. So Josh, on behalf of all educators in Sacramento, it's my pleasure to present to you and this commission this plaque as a token of our appreciation for your continued support of students, learning, teachers, instruction, and education in this community.
Very much.
Thank you. We also
give him a big hand.
We also want to provide our thanks and appreciation to the Board of Supervisors and specifically Commissioner Dave Cox for the resolution honoring SECC and its educational accomplishments in the community. And this is the appreciation that we received. It means a great deal to us to have our dedication and achievements recognized, and we appreciate your thoughtfulness.
Well, thank you.
So thank you very much.
You're welcome.
Thank you. And finally, we thank KVIE Channel 6 for its support of SECC. Having the award night at KVIE made the evening memorable for all, and especially for the students who participated in the video competition. Again, in closing, thank you for your support, and we hope to see all of you next April at the 6th Annual SECC Award Night.
Well, thank you very much.
You're welcome.
Thank you very much. Okay, our next, I see Access Sacramento.
How do you see the Toby seat?
I don't know. Anybody else?
Are you going to have enough members to adjourn? Because I got to go upstairs.
You have to go right now?
I'm now 10 minutes late.
You're now 10 minutes late. Ron Cooper, Executive Director at Access Sacramento. I don't know about that old adage that they say, never follow dogs or children in terms of trying to put on a presentation.
Ron, could you excuse me for a
Sure.
bit too? I was just trying, I'm 10 minutes late for an appointment upstairs that, and I'm wondering if you're going to have enough. I don't want to be rude. But
I think they're just informational items. It's,
is it going to be fairly short?
Give Dave your proxy.
I was teasing Liz. They took more than 3 minutes for their presentation, so as long as I mention that on my time. All right. Thank you, Ms. Collins. I'll keep it. I will say, Ms. Collins, my wife is paging me with the 911, so yeah. So if your husband's paging you, you may be excused. Or okay, well then we'll excuse you anyway. All right. I also wanted to start off by acknowledging the awards night was great, and Access Sacramento appreciates also being honored in terms of our collaborations with the ED Consortium, but you had to be there. It was really a wonderful, warm event, and we appreciated being involved and honored. April and May has been a very busy month, or is going to be a very busy month, and I just want to go over some of those key areas. In addition to the ED Consortium's acknowledgement, we were also acknowledged by the County Office of Education ROP program for our work in providing the studio for the ROP training and television. 2 of our programmers and programs have been named as finalists in the Bay Area Cable Excellence Awards. We'll know whether they've won or not next week. And so far there are 4 honorees, 4 programs being honored in the National Hometown Video Festival, and we won't know the outcome of that until mid-July. Finalist in hometown means you're one of the top 4 in the nation. Board activities, the board has been very, very active. We continue to move forward in terms of the 12th NC Community Communications Center facility, and are in the process of final negotiations. I should be able to report back next month, hopefully, as to the completion of that process. The process of new members on our board and our annual membership ballot. An annual membership meeting will be held June 16th at 7:00 p.m. Everyone is invited. And at that time, we'll have the results of our annual membership election for board seats available. One seat that was available, and I want to thank members of this commission and other concerned residents and constituents of Sacramento County for helping us in terms of our process of spreading the word about the availability of seats. One of the open seats has been filled with Walter Liang, Vice President of First Commercial Bank, and we're real proud in terms of the lineup of folks who are completing our board and on the ballot for this year's election. I also wanted to mention that the board authorized, and we've been working closely with Brian Gruber of Sacramento Cable, based on an initiative that Commissioner Yee took in the concern that C-SPAN 2, because of the channel allocation problems, Sacramento Cable subscribers are missing some very important discussions. And so working with Sacramento Cable, we just need to finalize the technical process, but that C-SPAN 2 from 5 to 7 p.m. will be carried Monday through Friday on Public Access Channel 18, so as to not miss any of those discussions. And it's been very positive working together, and thank you, Commissioner Yee, for your suggestions. We're also moving forward in grant projects, most notably the AmeriCorps, which is the administration's domestic Peace Corps process, working with on several different fronts in terms of AmeriCorps funding for Sacramento County residents. One that we're proposing to draft a proposal called the Thresholds Project, working together with, in collaboration with other nonprofit. We're taking the leadership, working with Francis House, La Familia Counseling Center, Sacramento County Regional Occupation Program, Sacramento Local Conservation Corps, the Tree Foundation, the Urban League, the Women's Center, and St. Hope Academy. If we are funded, then this will provide some AmeriCorps positions to assist our efforts and the efforts of these nonprofit groups in providing services to their clients.
Just in conclusion, one other important item that's coming up this month that we're going to be covering, because of the leadership that Access Sacramento serves throughout the region, we were invited to document as the official video production entity the open access hearing. These are hearings being conducted around the country. There's been one in Albuquerque, one in Los Angeles, and now one in Sunnyvale, conducted by the Honorable Larry Irving, Assistant Secretary of Commerce for Communications and Information, and Administrator of the National Telecommunications and Information Administration. This is the NTIA grants or something, another issue that we're applying for as well. And also with the panel will be the Honorable David Barham, Deputy Secretary of Commerce, and the Honorable Andrew Barrett, Commissioner of Federal Communications Commission. The purpose of these hearings, we hope in our documentation and bringing them back and showing them on the channels here, probably at least 6 hours of programming, is to, I think, in some ways complement what your executive director and staff are doing in the sense of helping this body and helping the your constituents in Sacramento County understand the full picture of the communications environment as it's shaping up. Certainly a critical area is on rate regulation and other FCC guidelines. But the good news, I think, in terms of something that's sometimes not looked at because it's so amorphous right now, is what is this new communications environment and how can the average citizen participate? And that's exactly what this hearing is to do, is to take witness testimony from all over California in the area of how can the public be served, in answering questions on who has access and who doesn't, what factors would help or hinder network access for information providers and users, and what is government's role in ensuring access and spurring innovation. So as we bring back that programming and run it on the channels, I'll be sure that all parties here can tune in and watch. And again, part of the ongoing process of helping Sacramento County to remain, as it has been, a leader in the area of innovation in the use of cable and now new communications technologies. Thank you.
Thank you, Mr. Cooper. Also want to mention that Access Cable will be televising a candidates forum on May 18th in my council district. It's a hearing, it's a candidates forum that will be at Caleb Greenwood School at 7 o'clock. The candidates are running for Council District 3. Okay, we have Mr. Gruber. Would you like to speak both on this item and the next one, and then just get it, just this one? Come right up. We'll go right into it. Next item.
As usual, Mr. Chairman, I will be very brief. Wanted to report again through the heroic effort of our customer service employees. The last report we gave to Mr. Espasto for our 15-day reporting period reported two numbers. One was a 10-second average speed of answer, which we're very proud of. Also, Mr. Espasto has pointed out that in years past, we always reported our customer service numbers, average speed of answer, including our automatic response systems, including our ARU and automatic number identification systems. We both agreed that while that is the way that the numbers have been reported, that in order for us to become the model for local quality service, we should be far exceeding any governmental standards. Therefore, what we will do for the next couple of reporting periods, just so as to compare apples to apples and let our employees enjoy the advancements that they've made for the last few months, is we will report both numbers. I don't have the report with me. I believe, Rich, if I'm not mistaken, it was 10 seconds without the automatic ordering telephone calls, and 16 seconds including, or the other way around, 10 seconds including them and 16 seconds without. Anyway, far below 30 seconds. And that's based on 100% of calls. The regulations call for us hitting the 30-second standard 90% of the time. In the entire month of April, just to give you an indication of not only a 15-day reporting period that we select for the quarter, but for the entire month of April, we had a 17-second with automatic ordering calls, and 23 seconds without. So our employees are very proud of that. Couple of quick things. I'd like to also thank Councilman Yee and Mr. Espasto and all the grantees, just to demonstrate the importance of active communication between the franchisee and members of the commission. A letter was received by Councilman Yee regarding C-SPAN 2, and as you know, because of the must-carry rules, we had to temporarily cut back C-SPAN 2's hours. As a matter of fact, we have one woman in Galt, you should know, who actually found out my home number, and anytime C-SPAN 2 is not on and there's something that she wants, you'll be pleased to know that she calls me at home now, Mr.
I gave her your number.
Thank you very much. Thank you. I was wondering. But we do have a policy now, first of all, that if we receive, out of our 216,000 customers, if we receive one telephone call by 5 p.m. when we go over to Bravo, we will leave C-SPAN 2 on while the Senate is in session until the Senate goes out of session. But basically, Councilman Yee wrote to me, I wrote a letter back, he wrote to Mr. Espasto wrote to the grantees, and I want to report that each of the grantees were extremely responsive. We discussed at length all the opportunities to increase C-SPAN 2's hours, and finally, as Mr. Cooper said last week, Access Sacramento voted, their board voted to allow us to carry C-SPAN 2 during weekday hours between 5 and 7 p.m., which is a marvelous vote in our opinion, and tomorrow I'll be visiting Mr. Cooper and his staff to work out the details of how we'll accomplish that. And finally, one other thank you is in order. We, of course, want to find all kinds of new creative ways to serve our customers, and one that was broached to us by people in the community was a project that we've named for the time being the Capital Channels. In addition to the California channel, which telecasts live sessions of the California State Legislature, they actually pick from 4 separate feeds of the Assembly, the Senate, and conference rooms. And what we are attempting to do is to, through the use of fiber optic and coaxial cable technology, deliver all 4 channels to lobbyists and government buildings in the L Street corridor and throughout the downtown area where people would find that valuable. In some ways, there are some aspects of the customer service regulations that are problematic in doing that, and therefore members of our team have gone to Mr. Espasto, who has been very generous in his cooperation of trying to work this project too. We still have a number of obstacles to surmount. However, we hope to begin providing that service once those obstacles are surmounted.
I'm certain that those will be in the basic services that you provide, I assume, too, Mr. Gruber.
Quite to the contrary, Mr. Chairman. We will charge a handsome fee to those who are willing to pay for it, and in order to cover the huge capital costs involved in providing that service to those for whom that service is so important. That is all I had. Unfortunately, Mr. Dickinson is not here, but I do want to point out that we don't inconsistently assess the late charge based on who's aggressive or not. However, we believe it's very important as a responsive service company that when a customer calls who didn't know about our late fee because we didn't provide effective communication, or their check was misposted, or there's any complaint, we believe that it is important as a service company to be very liberal in providing credits when that happens. So I want to assure you that's not an effort to try to be inconsistent. If there are any questions, I'd be happy to answer them at this point.
Brian, just a comment since you're here. The issue on multicultural channel, I'm still meeting with the group, so until we're through talking about it, we'll be getting back to you.
Thank you.
Hopefully we can resolve that one too.
Thank you. We're looking forward to receive the information that we talked about.
Fine.
Okay. Thank you, Mr. Gruber.
Thank you.
Okay. The final item, any members of the public wishing to speak on items not on the agenda?
I think that's going to end up runoff.
Oh, during this as well? Okay, please come right up. I'm sorry, I put yours away here.
Ordinarily, when it's this late, I would really demur in the interest of everybody's dinner. But this is a really important day. It's Cinco de Mayo. It's Dia del Grito. It's a day in Mexico when sort of a ragtag handful of farmers and merchants and people with not much to fight with stood up in the Puebla and defended their little town and defended their pride and heritage after decades and decades of domination by the French and by the Spanish. And it became known as the day, the sort of shout that was heard all over the country when they really regained their pride and their heritage and really started taking their country back. And the reason I'm saying this is because we have a number of Hispanic employees, and they've gotten together over the last few months and they've formed a group that sort of dedicates dedicates itself to celebrating these kinds of occasions. And the last 2 weeks they were at Dia de la Familia in Old Sacramento, and then at the traditional celebration in Southside Park this last week. They put a tremendous amount of energy into representing their country and really celebrating their heritage. And so I want to take this opportunity to tell you about them and to say thank you, because I think some of them just might be in the lunchroom. Everybody turns Oprah off the first Thursday of every month and watches the Cable Commission meeting. I want to say thank you to them. Muchas gracias a nuestros empleados. Y feliz 5 de Mayo, and the same to all of you. Thank you.
Grazie. Okay. Any members of the public wishing to come before the commission? I see none. Just one item I missed when we went through. The point about Easter being included. Could we also look at Passover as well? See what the cable company has to say, and
their request was based on service volume in their lobby.
Yeah,
If they have members support that, be glad to consider.
I just felt we should look at Passover as well. Okay. All right. Well, if there's no other items to come before the commission, it's been moved and seconded, and seeing all in favor, we are adjourned.
Coverage of the environment, arts, religion, and the history of other major issues.
It's All Things Considered. I'm Linda Wertheimer.
And I'm Robert Siegel. By a narrow 2-vote margin, the House of Representatives today passed a measure to ban the manufacture